there's an order stay in operation, it is not proper for me to seek an adjournment. But my friend,
it's only an undertaking, submission made by the land.
No, I'm ready to argue.
Yes, you can argue the matter.
I can argue them. I'm not asking for adjournment. My father is in the hospital. I'm not asking any adjournment. No, yes. I will argue for that also. No issue.
You relinquish the wakalat in that matter because yes, you can argue this matter written till 2629 you can argue.
Yes. Now, the all protection I see is based on a notification.
Mr. Counsel, before starting your arguments, the previous repetition, that is WPC 46514 of 2024. One of the relief sought for is in respect of this cap of 25 crores.
Yes.
And against which there was a writ appeal entered in dismissal. Review was there. Review also dismissed, and thereafter SLP also dismissed.
Yes.
This is one of the specific relief sought for in that repetition.
Yes. Now we can say that it should not be taken as a lack of humility, but with all humility, not an arrogance, all humility. I always say,
before starting your arguments, we will also point out that you have to finish your arguments with the minimum time. You will certainly grant you time.
Yes.
But others are also waiting. Large and the batch of matters are also listed here as part of the
I definitely appreciate.
Now you can.
I definitely appreciate. I always say judgment has to be brief.
Now you can make your submission. Now you can make your submission.
Yes. Now, in all humility, I should not be mistaken. The consistent stand as a lawyer which I am really bound to take is that I don't seek any favor, respect for any favor from the court. And if the law entails something in favor of my client, if I am entitled to my client, then I mean my client is entitled to something, then I am duty bound to, my lord, do whatever is humanly possible to protect his right. That is what Dr. Bangam, the pronunciation may be difficult, it said in the case of
counsel come to the point issue is
now, I'm only on that. I'm saying that I'm not seeking any favor from anybody, but I'm entitled to what I'm entitled. My grievance here is what my client is entitled in law as a matter of right, not equity, not charity, with utmost humility, that has been denied. And my lord, my plea is that I rely on the lay. And my lord, the fundamental principle, actus curi neminam grevavit, a mistake of a court, an error of court, can cause no injury to a litigant. And where the court is wrong, it has to correct itself. Ex debitio justitio. That is called the inherent power. People accuse me of using Latin maxim, but there is no other way that this expression can be used. And I rely on Andile. And Andile allowed aid to yourself from Andile. There is no reference at all in the judgment about Andile. The Andile says the inherent power of the court. Lex alicti, aliquid, considerare, vidate, rasipsa, essay, non-contest. The court has a power, a duty to rectify its mistake. And if the court, my lord, if your lordship has passed an order, signed it but not pronounced, then your lordship can make changes without notice to the parties. And if the court has pronounced a judgment, and after that your lordship has noticed that my judgment is against the law, then your lordship is duty bound to correct it. But there is an obligation to give notice to the parties, for the parties. So the duty of the court is to correct an error. Here I came here with my lord, based on seeking the protection of a notification dated 29/5/2015, which has received the assent of both houses of the parliament, and therefore it is an act of parliament. It has a statutory force. A lawyer should be knowing that. But that plea was going to be rejected. And my lord, now a judgment in a case between A and B, my lord, right or wrong, will bind the parties. And my lord, if a judgment in a case between A and B will not bind C and D, and that a judgment where a judgment is on facts, The doctrine of res judicata is only on facts. First principle, doctrine of res judicata has no application to law, and that is why in court of opinion, all this law comes from Rome. There is no way making, being sarcastic about me quoting Latin. All law has come from Rome. Four sources of the common law, and the common law is the law of the land under by virtue of Article 372 of the Constitution of India. The Roman law, the common law, which is our law, which we adopted by virtue of Article 372 of the Constitution, has four sources, and the most important source is the Roman law. Second is statute, third is precedent, and fourth is custom. And the Roman law has its foundation in the Justinian's Digest. I refer to, today I have not got any of those books. I refer to extensively from Everest on Estoppel, from Bigel on Estoppel, then Casperus on Estoppel, and a small book also, Hanley on Estoppel. And then, my lord, I read the from Justinian's institutes. Just civilis, the entire maxim I am not able to recollect. That the doctrine of Justinian codified the writings of Ulpian. Ulpian said, "Res judicata pro veritate accipitam." A judicial decision has to be taken as truth. Thus, things judicata pro means pro, veritate means truth, accipitam means accepted. A judicial decision has to be taken as truth. Or judicial semper pro veritate accipitam. What is decided by God has to be always taken to be truth. And the reason why, my lord, is interesto republico ut sit finit litium. It is in the interest of the republic that there shall be finality of litigation. And therefore, again, my lord, the concept of nemo debat vis vexadi pro uno et iram cosa. No man shall be vexed on the same question more than once. Therefore, Ulpian said, res judicata facit ex albo nigrum, ex nigro album, ex recto verbum, ex curvo rectum. A judicial decision on facts can make what was white black, what was black white, what was straight crook, what was crook straight, what was straight crook, and what was crook straight. Res judicata facit ex albo nigrum. Albo means white, nigrum means black. Ex curvo, ex recto curvum. What was rectum is straight, curvum is curve. Ex curvo rectum, what is curve. So therefore the presumption is, when a court finds on facts 1 plus 1 is 0, then I am bound by it. And the courts, it has happened in innumerable times, and courts have found innocent men guilty of even murders and sentenced them to gallows. They have been hanged. So therefore that has happened. And I can say in the recent past, I know from my friend of mine, Adhikari, that a lift operator in Calcutta, leading to the popular sentiment, was hanged. And the Bharacharya understood that he is an innocent man. He lost his senses even. So therefore that has happened. So that is why my lord Ulpian said, Via Justitia Ruat Sealum, in the earlier building of the High Court in the Chief Justice Court. Via Justitia Ruat Sealum is written. What is the meaning? Fiat means authority of the court. Via Justitia, the authority of the court shall be given effect to even the heaven should fall. That wrongly translated as heaven, even if justice should be done, even if heaven should fall. That is what is translation. But the Latin meaning, literal meaning is, and Justice Krishna has done with it. Meaning is that even if heaven should fall, a judicial decision, also unjust, erroneous, it has to be given effect to. But my lord, the court is a servant of justice. We are all servants of justice. Somebody says a lawyer is an officer of the court. I refuse. I refuse to accept. I'm not any officer of the court, because Bar Council rule says I am an officer of the court. I don't bound for that. But I am a servant of justice. Servant of justice. I always say lawyers and judges and servants of justice. They are the two sides of the same coin. The judge is not superior to lawyer. Lawyer is not inferior. No way. Both are part of the same system. And therefore, my lord, this decision, the basic judicata for the Ulpian, then again said, and that part of the maxim I read it, but the rest I don't recollect entirely. Si omnia sur dignum, idem corpus, idem conditus, idem jus, idem causa petendi, idem conditio personarum. All this happens. Then, my lord, if there is a idem causa, see omnia sut idem, the earlier sut has been in respect, it should be the same in respect to every matter. Idem corpus is body, idem quantitas, quantitas obviously quantity, idem just very same right, idem causa petendi, concerning the very same cause of action, roughly translated. And my lord, idem conditio personarum, all this has to come. And my lord, I have explained everything. An instance of a cause of action, as in the instant case, they can lead to three cause of action. One is there is a statutory provision. The notification says, bank shall not classify an account of an MSME as NPA. It shall constitute a committee. They are duty bound to identify its and stress, constitute a committee, and then make a resolution application to the committee. And the committee will act as a judicial tribunal, issue notice to all concerned. Then the committee may direct the party to make further investment, make him obligatory to make further payment, and the bank may also contribute to for revival, or it may simply grant restructuring, and the committee may permit recovery, and that decision is final binding authority in terms of the notification itself. Para 6, para 11, it says the decisions of the committee shall be binding on all the parties. The parties before the committee are the banks, the financial institutions, myself, and unsecured creditors. The committee is duty bound to issue notice to everyone who has an interest in the resolution of the process, including the state. And that decision is rejudicated. The committee is a judicial forum without any of the trappings of a court. And this decision is final. What distinguishes a judicial body from an administrative body or a quasi-judicial body is, in a decision of a judicial body is authoritative, final, binding. It constitutes adjudicata, right or wrong, it is binding. Or decision of a quasi-judicial body doesn't bind anybody. The word judicial and quasi-judicial is often misunderstood. Now, this is what my case, and I pointed out to Justice the General Secretary that here my cause of action is based on three aspects. One is there is a statutory prohibition not to classify my account as NPA. They did it. In spite of I claiming I am an MSME, in spite of I pointing out when 13th notice was issued that an MSME, and therefore whatever has been done contrary to law is null and void of any issue. And the notification which my lord put such a restraint, prohibition, does not provide for any punishment or penalty for violation. Therefore, the only if I can seek a damages and compensation, that maybe I can go to a civil court. But since we recognize the concept of my lord, the public law remedy, where a statutory prohibition has been violated, then a citizen can approach the King's Court, that is the High Court, and seek a prerogative writ, a writ of certiorari, writ of prohibition, and a writ of mandamus, and now, my lord, even a writ of declaration of declaratory remedy even. Therefore, this is for this limited purpose only I came to the High Court. No other issues are argued. Nothing was pointed out. Only that, except that I only pointed out that I have to receive 85 crore rupees from the sale, and 85 crores from the sale, and gain, not sale, and another 35 crores from the smart city, and the arbitration proceedings is pending before Justice Nageshwar Rao, former judge of the Supreme Court. And my client went to invoke the arbitration proceedings, not knowing that he is protected by Chapter 4 of the MSME Act. May I take your lordship to the Chapter 4. Chapter 4 of the MSME Act. I made a mistake, Chapter 5. Chapter 5. The lordship got my lord, page.
Yes.
No. Delayed payments to micro and small enterprises. Section 16. Date from which and the rate at which interest is payable. I am not reading the entire thing, the last part of it, my lord, or any other law any law for the time being in force, be payable to pay compound interest with the monthly rest to the supplier on that account from time the appointed from time the appointed day, or as the case may be, from the date immediately following the date agreed upon, 3 times the bank rate of interest notified by the Reserve Bank of India. And then my lord, section 17, recovery amount due. Then section 18, reference to micro and small enterprise facilitation council. Notwithstanding anything contained in any other law for the time being in force, any party to dispute may, with regard to the amount due under section 17, make a reference to the micro and small enterprise facilitation council. Then there is no such council actually exists in Kerala. And the MSMEs, the RBI says, RBI notification says the financial literacy is 92%. The MSMEs out of the financial literacy, none of them have ever gone to the arbitration council. The arbitration council doesn't actually exist. So that is by ignorance of a statutory protection under the MSME Act. I invoked Arbitration and Conciliation Act, and my lord went to Delhi and got an arbitrator appointed. Now I will abandon that. Tied to, my lord, invoke the provisions of the my lord MSME Act. And my lord, your lordship will find, may take your lordship to section 19, how the parliament was anxious about protecting MSMEs. I take one word from my lord, section 19. Application for setting aside decree, award or order, section 19 of the MSME Act. No application for setting aside any decree, award or other order made either by the council itself or by any institution or center providing alternative dispute resolution services to which the reference is made by the council shall be entertained by any court unless the appellant not be has deposited with it 25% of the amount in terms of the decree or award as the case may be. So therefore, my lord, an appeal, the award of the arbitration council cannot even be challenged without paying 75%. And my lord, I take your lordship to paragraph section 22. Required to specify unpaid amount with interest in the annual statement of accounts. Where any borrower is required to get his annual accounts, audited by any under any law for the time being in force, such a buyer shall furnish the following additional information in the annual statement of accounts, namely the principal amount and interest due thereon to be shown separately, remaining unpaid to any supplier at the end of each accounting year. Any amount of interest paid by the buyer in terms of section 16, along with the amount of the payment made to the supplier, etc. I am not reading further. Therefore, the Parliament, when enacted MSME Act, had in mind 2 things. MSME should be protected in case from falling sick. It's a preventive legislation, prevent them from falling sick. And wherever they have fallen sick, it's a remedial legislation, revive them. And that is one thing. And the revival process and protection mechanism include recovering whatever amount is due. And that is the reason, my lord, in the writ petition, I made the Steel Authority of India, the Gas Authority, Gas Authority of India, and also the Bharat Petroleum Corporation, GAL, page 115, my lord, respond number 11. In GAL India Limited, represented by General Manager, etc. Then respond number 12, Bharat Petroleum Corporation. Respond number 13, Cochin Smart City. And my lord, I have made also a report on the party array. This respond number 9, Chairman Micro and Small Enterprise Facilitation Council at Trivandrum, General Manager District Industry Center, then the state of Kerala. Then my lord, therefore no notice was issued to them. If my submission was, let the case be directed to pay some money. The bank's claim is 33 crore. Even if 50% of my claim is, my lord, directed to be paid as an interim measure, which this court under Article 226 certainly is empowered to. Or at least issue notice, let us see what the bank has to say. Nothing was done. And my lord, now, See, my lord, a scenario where I lost a case because of judgment's court only. My lord, Krishna here said, the judge's court ought not be in the dock. I am entirely quoting Krishna here. The judge's court ought not to be on the dock. Here the court is on the dock. Right from the single bench to division bench and the Supreme Court. Court is on the dock, not me. What is contemplated? What is contemplated? I am not required to make an application. If I may, if I see so, sorry, if I please so, the duty is on the bank to identify incipients. And at least in the case where there is a default, when they notify the default, they classified my account as NPA because of default. And the notification at page 70 says, yes, where the SMA 1, principal or interest payment overdue between 31 to 60 days. Page 70 may not. There's a default, there's no option. This is that day and night. The claim of the MSME is a day and night. There is no answer. There is no answer to deny it. It's day and night. So clear as daylight. And that relief was denied. In my case, look at that. Now the Supreme Court has come with, when I write you a judgment, any matter, now I am made Attorney General a party in all cases. After 43 years of the bar, I have to do that, make Attorney General a party to a proceeding, because it's a fundamental principle that any question involving question of law, if nowhere the government is concerned, still any question involving substantial question of law, the Attorney General ought to be heard. And that is what my lord CPC, Order 27 CPC, because Attorney General is the repository of the custodian of public interest. And a judgment concerned, because we believe we have the law, the precedent is one of the sources of our law we have recognized under Article 141, the law declared by the Supreme Court. Now the law declared by the Supreme Court is not the law of the land. Any principle, if my lord, if you evolve for the first time, which never happened, I cannot imagine one single case where the Supreme Court has evolved a principle which never ever existed, nothing new. But if a principle has been repeatedly reaffirmed, then that is considered, the courts and tribunal as bound by that. So I am not against the doctrine of precedent. I certainly swear by that. But precedent means stare decisis coetate non movere, stand by certain principle. Nobody is against the certain principle. Precedent is reason. Ratio decidendi, reason for the decision. Not the entire judgment running into millions of pages doesn't constitute a precedent. And again, my lord, the problem of the court is just essere, non just dere. Judicis est just dicere, non just dere. Judicis means judge, just means law. Judicis est just dicere, non just dere. The province of the court is to, my lord, declare law, not to write, not to be a parliament. And that no judgment can be read as a statute. No judgment can be read in substitution of a statute. And if there is a conflict between a judgment and a statute, it is the statute that will provide, not the judgment. And that is, to plead contrary is against the basic principles. It's against the basic principle. Whatever I say is a universal principle. Nobody can deny it. Universal principle. And therefore here, the notification does not require me to apply, but I did apply. Your Lordship, may I take your Lordship to the Lordship's most gracious consideration, my Lord. May I take your Lordship to my paper book? Yes, I take your Lordship to 173. I have pointed out it earlier also, but 173, 1 second. Page 173. I will not cite any judgment except Abdullah so that I save time. And Abdullah also I don't have to cite it. My Lord, the principle is, my Lord, the doctrine of the doctrine of nullity. Nullity comes from where? Less injustia, non as less. Saint Augustine. Less injustia, non as less. Even before Saint Augustine also, the concept of nullity existed. Aristotle. My Lord, less injustia, non as less. Therefore, an unjust law is no law. And Thomas Aquinas said, yes, and my Lord, that is what my Lord Chief Justice Cox said. coxed in Dr. Bunham's case. Dr. in Bunham's case, yes. Inicum est alicum, rui sui est judicium. If Parliament were to make a law, you are one of the parties to dispute is a judge thereof. Well, such a law is void. That is what Chief Justice Cox said in Dr. Bunham's case. Inicum est alicum, rui sui est judicium. Therefore, there is no need to cite any judgments. But I am burdened. People come with 101 judgments which has no legs to stand, which contradicts itself. And that is the reason why I cited one judgment on the link. Otherwise, I don't touch a judgment. By first principles. A judgment has to be brief. A judgment cannot be running more than 10 pages or 15 pages. Anything rest. Keshavananda Bharati, look at my lord, what a tragedy it is. What a tragedy. We are in a constitutional democracy. A lawyer has the freedom to criticize. Before Keshavananda Bharati, if a litigant comes to a court, the court will ask, what right of your
So counsel,
yes,
come to the point, come to the legal issues involved here.
Yes. Now coming to all that I can say, one word I can say is how great a error Keshavananda Bharati. Before Keshavananda Bharati, people used to come to the court saying that my fundamental right is infringed. And after Keshavananda Bharati, Article 32 is involved saying none of my rights are infringed. The basis structure infringed. And no judge asked the PAL wala that if the basis structure infringed, but it does not cause any injury to your fundamental rights, in what way you are concerned? And if you are really concerned about the fundamental rights, then you say that. And that simple and that absurd is the Keshavananda Bharati judgment, which is called, which some people say as the North Star. It is wrong. It is very human. It needs to be corrected. In a democracy, the lawyer should be criticized. I am not saying that whatever I say is correct. I am subjected to all kinds of ridicule and criticism. I don't have anything. I have nothing. I am free. I am nobody. I can be criticized, ridicule, everything. People do it. I have no quarrel. But the freedom of speech, that is so precious, and that alone will, my lord, sustain the democracy. And my lord, at page 173, SMS0, signs of stress. Illustrative signs of stress for categorizing an account as SMA0. This all our checks, etc. I am not reading to save your lordship said. This is the RBI's own guidelines. RBI's own guidelines at page 161. In furtherance of the notification, same time I am not reading it. In furtherance of the notification dated 29/5/2015, the RBI issued a notification asking the bank to identify incipient stress and telling them these are the illustrative signs of stress. But my lord, now that nobody, not a single bank or financial institution in this country gave effect to this notification. And my lord, this issue was raised. And my lord, take your lordship to a few judgments. This issue was raised in a number of judgments. And my lord, the first obstacle we found was that a judgment in the case of Bharat Mahendra. One second, my lord, this is to point out how you are, as Krishna has save us from the court. Save us from the court. I am quoting Krishna off the bench. Save us from the court. I am harmed. MSMEs are prejudiced, are put to a jeopardy by courts only. Banks did, yes. When I came to the court for protection, the courts all did it. And my lord, if it is corrected today, it has to be corrected. There is no point in it is impossible to be covered up. Now this issue has gone to many high courts. I myself traveled to various high courts so that other lawyers pick up this issue. Now I find in Karnataka High Court, everybody is taking up this issue. And in Kerala High Court also, lawyers will pick it up. So when this protection of the MSME notification is raised by hundreds of lawyers, then it can no longer be denied. Yes, I take your lordship to the Bharat Mahendra. Yes, one more copy. And my lord, I take your lordship to section 26E of the Surface Act. 26E of the Surface Act. This amendment was brought about by Act number 44 of 2016, which came into effect on 1/9/2016, page number 49, section 26C. priority to secure creditors. Lordship got my lord. Priority to secure creditors. Notwithstanding anything contained in any other law for the time being in force. After registration of security interest, the debts due to any secured creditor shall be paid in priority over all other debts, and all revenues, taxes, cess, and other rates payable to central government or state government or local authority. Yes. Now this is the, so before that, my lord, section 24 of the MSME Act says, notwithstanding anything contained in any other law for the time being force, the amounts due to the MSME shall be have a priority, and the monies due to the MSMEs are required, my lord, covered as a, my lord, recovered as a public debt under the Revenue Recovery Act, Revenue Code. Now, my lord, in respect of the property of a one gentleman who had borrowed from the bank, pledging his property, and from me, the MSME, purchase goods. My lord, both of us went on to proceed against him for recovery. I have got a recovery certificate from the Revenue Authority, and the bank invoked the Surface Act. My lord, got a advocate commission appointed. Then the issue came between the two creditors, MSME as an unsecured creditor and the bank as a secured creditor, who will have the primacy. This was the issue. This was the issue. It has nothing to do with the dispute between a borrower and a lender, and bank or financial institution. And this judgment, the Supreme Court said, by virtue of section 26E, the provisions of the Surface Act will prevail. And then that was the judgment. The Surface Act will prevail over the MSME Act because it is a later law. Yes, paragraph 26, my lord. The short question which is posed for the consideration of this court is whether the MSME Act would prevail over the Surface Act. The question of whether recovery proceedings or recoveries under the MSME Act would prevail over the recoveries made or the recovery proceedings under the provisions of the Surface Act. And paragraph 29 and 30, it has been answered, saying that the section 26E is a later act, and therefore it will prevail over the MSME Act. Last paragraph 30, last sentence, only reading one sentence. The aforesaid is to be considered along with the fact that under the provisions of the MSME Act, more particularly section 15 to 23, no priority is included with respect to use under the MSME Act, like section 26E of the Surface Act. This was the issue. Then this judgment was cited ever so many occasions. Here before Justice Benjamin Thomas rejected all line of petitions quoting this. Again, the Justice Govinath, and in Bombay High Court, ever so many, in Kannada High Court, in Madras High Court, this judgment has been used, which has nothing to do with the MSME and the borrower, the banks, as a justification for rejecting the claims under the MSME Act. Even in the A. Naveen Chandra case, we have produced it here. So the A. Naveen Chandra is a judgment where a batch of matters were referred by a division bench of the Bombay High Court, and the court came to the conclusion. In A. Naveen Chandra, the court said there are thousands and thousands of MSMEs. It is impossible for the banks and financial institutions to identify incipient stress, and that the benefit can also be extended only to those MSMEs who had applied for. And in challenge of that order only, my lord, the appeal came to be instituted in the Supreme Court, and thus came the judgment of the Supreme Court in Procedural. And in A. Naveen Chandra, this Kodak Mahendra was quoted and said the Surface Act will prevail over the MSME Act. Now, my lord, now the learned single judge rejected my plea on the ground that I had come earlier. I take your lordship to the impugned judgment. The only reason why my plea was rejected is the judicata. Yes. Now, my lord, my lord, lordship said, the learned secretary has referred to a large number of judgments, a large number of petitions which I find at page 7. Sorry, not page 27, paragraph 7. All these petitions were on the sole premise of protection in terms of the notification dated 29/5/2015, which was entirely based on a statutory statutory instrument. And as I said, my lord, my case is founded on 3 premises. Violation of the statutory protection, that is public law remedy. There is a breach of contract. I am entitled to compensation, for which I have moved the Bombay High Court, the suit in the city Bombay High Court. I am entitled to compensation for in tort. That also, these are 3 distinct cause of action. If a cause of action under the public law remedy is decided one way or other, that will not stop me from prosecuting the remedies under the contract and under and tort. And my lord, this issue I had occasion to argue before the Bombay High Court, and the Bombay High Court held, and the Bombay High Court held that in paragraph 18 of the judgment. Paragraph 18 of the judgment, Bombay High Court that only the plea in terms of the MSME notification has been considered, but other plea, the petitioner is entitled to, my lord, invoke whatever remedies offered to grant. So therefore, this is, I said the judgment, paragraph 18 of the judgment of Justice Shyam Suman and Manjula Deshpande, I get the judgment. So that judgment I am not citing for a judgment. This is a principle. I don't need any judgment. That there are 3 independent cause of action. Cause of action accruing from the bank acting in violation of the statutory prohibition. A cause of action accruing for arising out of a breach of contract which I allege, where all burden is on me, which I did in the city Bombay High Court on the civil side, suit. And the cause of action distinct from contract based on tort, malicious and tortious action. And there are 3 distinct ones. And here, what was pleaded was the protection under the MSME Act. And that protection was denied to me not on the factual ground that I am not an MSME. Supposing that there was a decision holding that I am not an MSME for XY reason, maybe the reasoning is absolutely wrong, then there is a element of facts. If on facts the court is free to err and bind the parties. On law, the court has no jurisdiction. On a pure facts. So here, my lord, I take your lordship to the notice under section 13(2). Notice under section 13(2), and my reply to the notice under section 10. Even before that, my lord, I take your lordship to the non-sanction also, at page 174. Only 1 second. Page 174. This is MD Estepan to Anup, etc. Yes. Please find attach the certificates. Attachment Udyog Aadhaar sign, Udyog registration certificate, MD Udyog, etc. Yes. Then bank next page at page 175. DLP Angamali to MD Estepan, etc. Please apply Udyog registration number through online. Then, my lords, now they issued a notice under section 13.2 yes, at page 177. And I replied to the same by letter dated 11th of October 2023, page at 183. Reply/objection under section 13.3a of the Secretarization and Reconstruction of Financial, etc., etc. Now I take your lordship to page 184. Para 3. MD Estepan Infrastructure Private Limited is registered as a small enterprise under the MSME and having the MSME Udyam registration number, etc. That while notice dated 16th August 2023 it is declared that the following credit facilities, namely, etc., as non-performing asset with effect from 31/7/2023, etc. Then the statutory guidelines provided by the Government of India by the, etc., notification dated 29/5/2015 for the framework for revival and rehabilitation of micro, small and medium enterprise for the purpose of facilitating the promotion and development of micro, small and medium enterprise, thereby providing instructions for the revival and rehabilitation of MSMEs were not adhered to prior to the issuance of this notice dated 16th of August 2023. Guidelines should have been mandatorily followed. Statutory operating instructions of the Reserve Bank of India, etc., dated 17th March 2016, whereby directing all attached commercial banks to formulate a framework, etc., etc. Then, paragraph page 185, I'm detailing. My lord, the only thing I replied in the notice is that last sentence. The reply is primarily saying that I am entitled to the benefit of the notification. Paragraph last paragraph. Hence, owing to the non-adherence of the mandatory statutory provisions, this was probably is only one of the litigants who have replied this way. Mandatory statutory provisions which should have been applied before the issuance of notice. It is required to withdraw the illegitimate notice dated 16th August 2023 and to provide necessary specific corrective action plan to our firm, being an enterprise included in the MSME Act of 2006, by implementing necessary steps precedent to declaring, etc., etc. Now, then the bank replied to it. The notice under section 13.2, the bank replied. May I take your lordship to page 187? Nothing is said. Paragraph. As the bank is dealing with page 188, as the bank is dealing with public money, prudence requires the banks to exercise necessary guidance to recover money in NB accounts, etc. Now, so they were concerned about public money. Now, my lord, may I take your lordship to that convention, how the banks and financial institutions treat MSMEs and Ambanis. I take your lordship to page 573. And we are making Ambani every case a party. Let the public in this country, let them realize that this is how the banking institutions, which are clothed with the statutory power to act, their banks are being permitted to become a judge of his own cause. But contrary to what Chief Justice Cobb has said in Bandhan's case, against the first principles of jurisprudence, the more protest, essay similar to actor, nobody can be a judge and an actor, the plaintiff at the same time. The more the better, essay jurex in propria sua cosa. So whenever banks have been entrusted with the judicial power, statutory power to be an actor and a judge both at the same time, but keeping the public interest in mind. And your lordship will find against Ambani at page 573, against 49,000 crores. What was recovered is 455 crores. That is 92 paise per 100 rupee. 92 paise per 100 rupee. And in another case, in Anil Ambani only, it is 35 paise per 100 rupees. 35 paise, 10,000 crore. 35 paise per 100 rupee. And there are many other such cases. And maybe because we took up the issue, now some cases registered all make believe, I believe, by the ED, etc. against the Ambanis. So therefore, this is how the MSMEs are treated and how the big corporations are dealt with. Now your lordship will find. Now, I replied to the notice under section 13.2, pointing out that I am MSME, and the bank's reply is, there is a recovery of public money. That was no answer. Then, my lord, I again wrote to them at page 189. At page 189. And again, my lord, I may take your lordship to, I repeated that in MSME, whatever you have said is all wrong. Then at page 191, I wrote to the notice. Yes. I wrote to the notice that I have to recover 85 crores from BEL, Bharat Electronic Sector, right? GAIL, Gas Authority of India Limited, Cochin Smart Mission. So therefore, I pleaded that case. Paragraph 10. The legal action of classifier respond as non-performing with effect, etc. by fraudulently evading the statutory provisions has also resulted in an inappropriate accounting adjustments by the bank amounting to rupees 45 lakhs transferred to RDS projects, etc. etc. These are appropriation fine. Now, my lord, I sought a protection. I go to the notice that yes, I have to recover so much of money from the GAIL, BEL, and Cochin Smart Mission. Therefore, in the writ petition before the General Secretary, I made it a party, and I pleaded at least notice be issued to the GAIL, so that at least my plea was at least 50% of the amount, or whatever 33 crores, which is what is due to the bank, let it be paid, so that my account would be my account would be regularized. So there is no word, there is not even a whisper about my contention in the judgment. And all judgment is on the sole premise that I had come on an earlier occasion, and therefore I stand as prudent. And my lord, that was without my lord meeting my convention that res judicata applies to facts. Res judicata does not apply to law. And therefore, in the earlier proceedings, nothing of any factual dispute, even as to my entitlement of the MSME Act, was not considered at all. Nothing was decided. Therefore, where the court has gone down, actus curiae, eminent gravit, and extensively citing from Mandalay, it is a duty of the court to correct a mistake by whenever it is brought to his notice. It can be, the nature of the proceedings are irrelevant. The court is duty bound to act in suo motu, or or the party brings it up to notice by independent proceedings or review, whatever way. The procedure does not matter, and that is what has happened in Andalay's case. Andalay was prosecuted under the Prevention of Corruption Act. Under the Prevention of Corruption Act, the special court is the court of the session judge, and the Supreme 5-judge Constitutional Bench of the Supreme Court, without noticing that statutory mandate, directed the Chief Justice of the Honorable High Court of Bombay to constitute a single judge, nominate a single judge to act as a special judge, and then Andalay challenged it, and eventually the Supreme Court said the 5-judge Constitutional Bench, the Supreme Court, the highest court of the land, my lord, when it comes to where the statute has not conferred jurisdiction upon it, you cannot by erroneous decision confer a jurisdiction upon it. If there was no, the Supreme Court had no jurisdiction to direct the special judge, the Bombay High Court judge to act as a trial court, and the directions were rendered void ab initio. Void ab initio. And when it comes to, when I refer that judgment, were rendered per incuriam. And therefore the court corrected it. And the court said it is ex debito justitio. That is what the law judgment coming into this judgment, entire judgment, there is nothing else. The judgment is only about the doctrine of nullity. The judgment is only about that there is no estoppel against law. Where the mistake is a pure question of law, then the court is duty bound to correct it. The learned single judge did not even make any at all discuss. Today at all, completely gave, I argued. Today I am not taxing your lordship's time. Your lordship said that I have to keep a time frame in mind. I have in mind. So, my lord, until I refer to your lordship the paragraphs, and I give a detailed argument note. I submit that argument note again here. The relevant paragraph extensively quoted from Andale. And the principle is, my lord, there is no estoppel against law. If a judgment is contrary to a statute, then, my lord, it is a duty of the court to correct it. And that was the plea which I made before the learned single judge. And, my lord, there the learned single judge not only did not, my lord, take notice of my contention, did not rely at all on Andale and the argument notes which I gave, but, my lord, discriminated me with another case. There are only two cases, to my knowledge, where the protection of the MSME Act has been allowed by any court in this country. Yeah. Or maybe three cases. All were instituted by. May I take your lordship to the judgment which I have next? PDMC at the hands of Justice Muhammad Nias. Yes. Yes, at page number is page started page number 40. When it came for admission, at the initial stage I appeared. പിന്നെ ആരോ പറഞ്ഞു പൂന്തോട്ടത്തെ ഏൽപ്പിച്ച ഓർഡർ കിട്ടും.
Mr. Counselor, you can address arguments around these type of submissions.
Yes. Then my lord, the brief was changed. Somebody has appeared. I take your lordship to page 27. Paragraph 31. The objection raised by the respondent bank that the writ petition is barred by res judicata due to filing of earlier writ petitions. Petition numbers 29909, 324.98 and 32643 of 2023 and subsequent proceedings in RP number 535 and 536 of 24 and writ appeal numbers 787 of 806, 835 2024 also cannot be sustained. In the petition number 4414724, the last in the series of petitions, the court has especially left all contentions of the petition is open. Given the above, none of the judgments cited by the respondents applied to the facts of the case. There was nothing for a court not to say nothing is open in my case because the entire cause of action was not there. The doctrine of res judicata to apply, I must say with all humility, the doctrine of res judicata is not understood to many of the lawyers and judges. The doctrine of res judicata to apply, there must be a complete termination of list. If your lordship dismiss this case, I kept my writ petition ready to be filed, which will come before the single bench for a new cause of action. Unless there is a finality, unless there is a termination of cause of action, there is no res judicata. Dismissing a case is of no consequence. I tell you, Manisha Mata, she is the president of the MSME Association. Because she filed 76 times. Ever so many times dismiss. But nothing. There is no res judicata. Supreme Court dismissing a case is of no consequence. Because for a doctrine res judicata to apply, My Lord, the cause of action is a disputed offence. And that must, when it undergoes a process called transit to judicata, the cause of action, which is a disputed evidence, merged with the decree of a court, and thereafter it ceased to be in existence, and that is called doctrine of merger. If the cause of action is not found to be in existence by the court, then the doctrine of merger is not abstracted. It is only judicated. And therefore, and what merge is what is decided. If a decision was on the public law remedy, then that alone comes to the judicata. Other issue, that is called issue estoppel. It doesn't go to the judicata. It's only issue estoppel. Other rights persist. Other cause of action persist. If if my properties are still not taken possession of, someone was taken possession of, the properties are to be sold. There's a long line of litigation pending. There is no res judicata. Res judicata pro veritate accipitum. That comes when order one rule on CPC. Therefore, my lord, the British, my lord, they codified the law, the common law principle for the first time in 1859 for the colony called India. And there, my lord, the common law principles were, my lord, codified. That is why you find all the principles, doctrine of estoppel. The judicata you find in the CPC section 10, stay of suit. If one suit is filed, another suit of the same matter between the same parties is filed, then the latter suit has to be stayed. When there is a decision, that is called the res judicata. But there is a constructive decision, there is a constructive res judicata. If there is a proceedings of a representative nature, then there also the concept of res judicata applies. Section 12, bar of suit. Then order 1, rule 1 CPC. All parties, all causes, all controversies to be brought before one forum. So order 2, rule 2 CPC, all claims to be sought. And may not have litigant cannot be allowed to permit this without the permission of the court. If he does, then there is a bar. So my lord, then order 39, section 39, or specifically fact, section 41 specifically fact. Therefore, all the code, CPC is a codification of common law principle, and the doctrine of concept of res judicata is the very foundation on which the concept of administration of justice is built. Therefore, any system which could work would bring a scenario where all cause of actions, all parties are brought before one forum. It is impossible for a borrower to be lost. Impossible. Because the concept of creation of a tribunal in substitution of the civil code is unworkable. Anybody who has got elementary knowledge of basic jurisprudence will never think of creating a tribunal in substitution of the civil code. If our lawyers and judges should stop thinking of creating tribunals, all tribunals should be abolished. And what should we should build the lower court, civil court. Article 226 should be abolished. What is Article 226 has reopened? What has been abolished in England? In England there are two streams of justice, the Chancery Court and the Common Law Court. And that led to difficulty. And read Bendam, he fought for it, for amalgamation. And after his amalgamation, only the Judicata Act of 72 and 73 and 1873 and 75 came into existence. During Benda's time, 1852 Act came. 1852 Act says, common law court can grant equitable remedies, equitable court of equity can grant common law remedies, and this great great lacuna, what they don't get the appropriate way, that deficiency was resolved forever even before that was done in UK, in India, when CPC was amended, all parties, all causes, all controversies, and the court of civil under the civil court under the CPC is a court of plenary jurisdiction, empowered and competent to adjudicate any issue of a civil nature under the sun. It was a true constitutional court. And that is why under Order 27 rule A of the CPC, when a constitutional issue is there, notice has to be issued to Attorney General. So therefore, there is no point in talking about res judicata. There is no res judicata. Res has never come to an end. The dispute between me and my friend is continuing. It will never continue it. It will never continue it. Therefore, this was all argued extensively. The judgment does not at all discuss, my lord, anything other than res judicata. And my lord, res judicata can apply only if there is a factual education. And here, in my case, the court found there is a res judicata in the same set of facts. Same, only the name is parties, the name of the borrower is different, name of the bank is different, the name of the lawyers who appeared are different. Otherwise, the same set of facts. If there is no res judicata here, then I find it difficult to find the res judicata. I am barred by res judicata here. It is that will lead to, my lord. I said something in Malayalam. Yes, and my lord. Therefore, because that I don't want to repeat it. So therefore, my lord, this is a great injustice and issues. If your lordship is deciding something against me, then it has to be, my lord, issue notice to all concerned. Let them file a counter affidavit. Let every party come on the picture. The facilitation council is there, the MSME ministry is there, none of them ever have the Reserve Bank. My whole protection, or the all relief I sought is against the Reserve Bank. There are no notice was issued. And my friend said the 25 crore limit, the first principle. The government itself is a delegate, notification itself is a delegate to legislation. And delegate cannot further delegate. Delegate does, non purpose delegare, or to put it fully, delegate does, non purpose delegare. So therefore this judgment is without completely without any foundation.
Yes,
it has to go.
And
I have not cited any judgment to save time. And I rely on Andale, and I am giving my lordship an argument note.
Yes, counsel on the
If my lordship will permit me one word, I forgot to say. There is a judgment of the Supreme Court in Sami Samar. Your lordship is certainly aware of that. That judgment says, if MSME had at least pointed out notice of the bank at the stage of reply to the 13-2 notice, that it is an MSME. And in such a case, if that is done, the benefit of the notification cannot be denied. So, which I did, just pass on. And in the other case where this court has granted relief, nothing of the sort was done. But my lord, between similar cases, similar ought to be the judgment. My lord, paragraph 8. If your lordship will permit, I read the entire paragraph 8. So this is the only case, somebody at the stage of 13-2 notice said I am an MSME. In the other case, PDMC's case, yes. Now, one is a decision of the coordinate bench of this court holding inter alia that the notification is binding on the lending banks and secure creditors. Finding to the contrary by the High Court of Bombay in the judgment and order under challenge in the appeal was thus quashed. Though while stressing that the terms of the framework need to be followed by the lending banks and secure creditors before the account of the MSME is classified as NPA. This decision also lays stress on the obligation of the MSMEs by holding that it would be equally incumbent on the part of the MSMEs concerned to be vigilant enough to follow the process laid out under the said framework and bring the notice to the notice of the banks concerned by producing authenticated and variable documents, materials to show his eligibility to get the benefit of the said framework. It was cautioned that even an enterprise allows the entire process of enforcement of security interests under the Surface Act to be over, or having challenged such action of the bank or creditor concerned in the court of law or tribunal and having failed, such an enterprise should not be permitted to misuse the process of law for thwarting the action taken under the Surface Act by raising the plea of being MSME at the belated. This judgment, however, depth answers something which we have explained herein above, while construing the terms consistently to prevent undermining the rights of one central enactment confers on another. So I did it. And then, my lord, one judgment, my lord, that is, I did not read it, that is of the Madras High Court, Madurai bench. It is here. Yeah. Annexure 3, right, Annexure 3. Yes, understood. I will not. I will only read one or two sentences from Madras High Court. There, that was also taken notice of by the Learner Secret Judge. At page, I only one or two sentences only like I read it. Yes. I take your lordship to page 88. Page 88. This is my division bench. These are my clients because I couldn't. I difficult to travel to Madurai. I asked them to engage some other lawyer. At page 88, paragraph 11. In fact, Court Madam,
Yes.
in fact, when a specific question was raised by the bench, whether the Canara Bank has formed any committee which is mandated under clause 2 of the framework for revival and rehabilitation of micro, etc., it was submitted that no such committee was formed. Then paragraph 12, I am reading one or two sentences to save time. Further in the above clause 2, subclause 2, etc., it is specifically stated that stress micro, small, and etc., etc. Then, when no such committee was formed, then the stress MSMEs like the petitioners were deprived of any such opportunity to approach the committee. The bank is contending that the petitioner has not raised the issue of benefit of the MSME scheme at the earliest point of time. When there is no committee, then such a plea or the bank cannot be entertained. Not if the bank has constituted one committee in respect of any borrower at any time, your lordship may dismiss the case. Because one question nobody has, no courts have asked, put on to the bank. Did he ever constitute a committee? Why did he not constitute a committee? Why did you act contrary to the notification for so many years? It is not a benefit being denied to one single entity, it is a benefit denied to the entire fraternity of MSME. Then I read one more sentence from the judgment. Then the issue. Yes. At paragraph 19. In fact, at page 96. In fact, such a submission will clearly indicate the annulment attitude of the bank. In fact, the counter-affidavit bank will clearly indicate that all the banks were not inclined to follow the revival scheme at all, which is extracted as a. So there, in that case, there are many more than one bank. Then from the paragraph, page 97, one paragraph. From the top, second line, this court is of the considered opinion that the scheme has fixed a duty on the banks to constitute a committee, a duty to formulate a scheme for revival, and also shall incorporate clause for repayment of the loan also. The committee can ask them to repay. It is not that the committee is duty bound to give charity, no. The committee, once a committee is constituted, I cannot spend money in the way as I like. The committee has control over it. Then, para 20, the banks are the backbone of India's economy, and it is a duty of the banks not to kill the business units. And the bottom, the lordship says, the court is with a heavy heart is recording the fact that banks cannot act like a Shylock pound of flesh. Then the jurisdiction issue, I'm not claiming any benefit under since I claim the benefit of the MSME Act, since the Act has not created a forum in substitution of the civil court for adjudication of disputes, the jurisdiction of the civil court is not barred. If this court is not inclined to exercise its jurisdiction under 226, then I am liable to be barred, relegated to the civil court. And this court has, the paragraph 21, that was dealt with in a brief way. Yes. The next convention, there is an alternative remedy before DRT is outright rejected. Since the issue raised in the present petition is whether the bank can proceed under the Surface Act without appropriating a rival scheme under the notification of 2015, which is a jurisdictional issue. And all contention in the entire recovery proceedings without jurisdiction, and when there is a tribunal acts without which is the authorized officer, without jurisdiction, A certiorari is a matter of right.
Yes.
First of all, conclusion that there has never been a case before this court on the basis of the MSME notification is not correct. So as early as 2018, in the matter filed against Federal Bank, twice the 13-2 notice was withdrawn. Then committee was constituted to examine, but they delayed the matter and they moved as per IBC. With IBC, there was a prospective person came in Dubai to the company. It is not correct to say that it has never been examined. Now I'll just take my notes to the judgment, which is it starts from page 16 onwards. I'll take my notes to page 17. 17, the 8th line from the bottom. Starts with the words, the petitioners further content. That's on page 17, 8th line from the bottom. The petitioners further contend that the Exhibit P3 RBI notification dated 17/3/2016, which restricts the application of the MSME framework to accounts with exposure up to 25 crores, is ultra vires the parent legislation and cannot override statutory notification issued to the central government. So this is the central argument, and again on next page at para 3.1. The respondent submitted the petitioner earlier challenged the RBI's rupees 25 crore cap on restructuring in the petition number 4631 of 2025, but realizing the challenge would not succeed, withdrew it on 7/2/25 with liberty to amend WPC number 46514 of 2014. According to the petitioner file IN number 1 of 2025, it was petition C number 46514 of 24, seeking to incorporate the challenge. Now, the learned judge at running page 28, has given a tabular column of the petitioner's previous attempts before this court. It is not included what he has attempted at before Bombay High Court. Now, there are two other earlier petitions which are withdrawn, saying when the ground was dismissed, saying that you oppose that, there is a difference. Now, challenging MSME, he first filed writ petition, that is second number, writ petition number 46514 of 2014.
Page number?
Page number 28.
Yes.
Tabular column. The earlier one would be that the one at 46514, that is serial number 2. That is the earlier petition. When that was pending, the appellant filed petition 4631 of 25, specifically challenged the 25 crore cap.
Yes.
Then the London Single Judge is going to dismiss it because there was already a petition challenging the MSME notification. So my friend here sought permission to amend the petition. That was duly amended. And this question was considered on the fourth column at serial number 2. Says details in judgment held that claims were barred by rulings and provisions, etc., etc. Then the bottom, the court further noted that their loan exposure exceeded rupees 25 crores, hence outside the scope of MSME framework, which applies only to exposures up to 25 crores. So may I just stop for a bit. Now the RBI notification as well as MSME notification, it's got two slabs.
Yes.
Up to the level of 10 lakhs, it was up to the branch manager to consider restructuring.
Up to?
No, it was up to rupees 10 lakhs.
10 lakhs.
It is up to the branch manager or the concerned branch to consider revival, etc. Anything over 10 lakhs, up to 25 crores, was within the realm of the committee. And anything over 25 crores was excluded from this framework, and it was under the normal master directions of the RBI regarding restructuring, etc.
Yes.
Then, when faced with the judgment in 46514, the appellant filed repeat 481 and 484, which was the next page, the this brief.
Yes.
Which was in which the judgment of the learned assembly was challenged, in which it is held that 24 crore cap would apply. Now, both the split appeals were dismissed.
Yes.
Thereafter, the appellant moved SLP number so 17263 of 2025, which was again dismissed. Then appellant moved MA 1330 of 2025, it was dismissed. Appellant thereafter filed RP number 797 of 225, which also was dismissed. Thereafter, he filed petition 17614 of 25 with the contention, basic contention that SARFAESI action and recovery under the RDB Act cannot coexist. And he also said that the judgment in Transcourt was bad, etc. That was held against. That is at serial number 7. And that is now pending in the other 1811. That is the
Yes.
contention. In that judgment, at the time of admission, prayer was made for interim relief, which was refused. Then, thereafter, he filed the present petition. Main contention was 25 crore is bad, which resulted in this, the judgment which is imputed in this petition. Now, may I take, my lords, at page 31 onwards. I read the last portion of the judgment. This is after the tabular column, para 8. Despite the argument of the learned counsel to the petitioner, based on judgments and the textbooks cited above, that the writ petition is not by res judicata or estoppel, the same has to pay for the reasons to follow. This writ petition, the same prayer between same parties who considered a negative earlier and the petitioner having failed, is further estopped from re-agitating the identical issue by instituting successive repetition, as is barred by the principles of res judicata as well as constructive res judicata. It is right that res judicata and constructive res judicata apply with full force to writ petition proceedings, and earlier rejection bar the second petition unless there are changed circumstances. A change of form or replacing the relief cannot be res judicata or constructive res judicata. The doctrine of res judicata rooted in section 11 of the Code of Civil Procedure and reinforced by public policy mandates that a matter once finally adjudicated by a competent court cannot be reopened between the same parties. Explanation 4 to section 11 embodies the principle of constructive res judicata, deeming that every matter which might and ought to have been made a ground of claim or defense in the early proceedings shall be treated as directly and substantially the issue therein. Even an erroneous or mistaken decision on a question of law or fact operates as res judicata between the same parties. For what binds is not a correcting of the reasoning, but the finality of the decision itself. The rule extends to issues of fact, law, and mixed questions alike. While doctrines such as estoppel, waiver, and acquisits are conceptually distinct, they often reinforce bar res judicata when a party knowingly permits a state of affairs to continue. Ultimately, the principle upholds the rule of law and judicial finality, preventing multiplicity of proceedings, conserving judicial time, and protecting parties from being vexed twice over the same cause. Certainty of law, consistency of decision, and conformity of course, all flowering from the same, flowing from the same principle coverage, converge the conclusion that a decision once rendered must later bind like cases. That is a prior decision rendered by competent court identical facts in law is binding in subsequent proceedings on the same points, and such decision must govern later cases unless shown to be incorrect or rendered in manifest error. This is the given. In the paragraph, in the second case, the issue raised by this repetition was directly and substantially an issue in earlier litigation referred to above. While matters collaterally and incidentally in issue may not ordinarily operate as res judicata, matters directly or substantially considered in prior decision constitute res judicata. The petitioners cannot dispute the multiple ruling proceedings instituted by them and judgments rendered against them up to the Honorable Supreme Court. Thereafter, to re-agitate the same grounds is clearly barred. Accepting the contention on behalf of the petitioner would mean that the litigant can go on filing cases despite dismissal of their pleas if they feel that the decision is wrong, even without filing an appeal. And it will be the litigant's understanding that decides the maintainability of the subsequent challenges and not the inter-party judgment. 2. Each sale notice may furnish a fresh path of action, even when an adjudication on the points already raised of judges is legally impermissible. The Supreme Court has also consistently condemned duplicate and peaceful litigation as a serious abuse of judicial process. In Ceylon versus Sumati Prasad Dasna, the court comprehensively articulated the re-litigation of the same cause or issues, whether by re-agitating desired matters, raising issues that could or should have been raised earlier, or fragmenting claims across multiple proceedings, constitute a textbook case of abuse of process under the Anderson principle. The court made clear that merely changing the form or forum of such proceedings does not alter their obtrusive or replicative nature. None of the principles argued by the other forms of petitioner based on authoritative referred to about holds that a reflection can be filed with the same person, raising the same contention against the same adversary. None of the steps taken to avoid applies to this case. Litigation having now lost up to some court, the reconsidered on the merits of the case cannot be made. For a reason, I find no merit. So in this case, now this is, if this court were to entertain cases merely based on the stamina of a litigant to come repeatedly or its financial prowess to come and repeatedly, so there will be no end to a case.
Yes.
And this court, my lords have considered this question in the writ appeal, which was taken up to Supreme Court and dismissed.
Yes.
And the court was made to re-agitate the matter again, which is again dismissed. RP as well to dismiss. So this is a contention which he should have, or he has, but even if he has not, he should have agitated and repeated writ appeals, etc. Having not done or not succeeded, I'm humbly submit that this court is even barred by to consider it again,
yes.
even if doing so.
Is anything in reply?
Now all my grievances, I relied on unbelief. In support of my proposition that there is no estoppel or judicata on a pure question of law. If it is something mixed question of law, yes, judicata. Suppose there was an inquiry was conducted, whether I am entitled to the benefit of the notification, whether I am MSME or not. And I am an MSME, but the court has found that I am not an MSME. That is fine. As a judicata, that is why quoted. What is why quoted from institutes? See omnia sunt idam corpus, idam quantitas, idam jus, idam cosa petendi, idam conditio personarum. All this is to satisfy. If it is a pure question of law, there is no estoppel. There is no judicata because a court is barred from acting contrary to the law. Nobody can act contrary to the law, neither the bank nor the court. All are servants of law. Even the king. Somebody, when I made the attorney general party, somebody said, can attorney general be with a party? There's a case where the crown was called in witness. In the case of a duchess between a duke and I think King Charles I. In England, the king and the subject both are under the law. King is under no man and under no man, but the king is under the God and law. He is ever so high. The law is above you. Be ever so high. The law is above you. If the Supreme Court has the full 7 judges, 5 judges of the Supreme Court in Abdulah's case acted contrary to the statute. Court has no authority to direct a trial by the judge of the High Court. When the statute has said the trial has to be conducted by this sessions judge, Supreme Court found that court has no such jurisdiction, and that it was corrected. And there is no whisper about the judgment in this case. The Section 11 CPC, Section 11 CPC only deals about the doctrine of judicata. The judicata to come to that for a doctor judicata to apply. I'm completely swear by the doctrine of judicata, without which the legal system cannot survive. The judicata is no means to say something and deny justice. No. The purpose of the judicata is a party who has been made to suffer because of human limitations should be allowed to suffer. Because the concept of the justice which is founded on two pillars. Both pillars are made of sand. The first the pillar is that a judge can assuredly ascertain the fact correctly. No. No. The judge exercises discretion wisely. No. There is no guarantee. But even where the court, as I said the example where a court says 1 plus 1 is 0, is manifestly wrong. I am bound. My grievance is that the single judge made a wrong decision on facts. My grievance is that the single judge erred on law. Therefore, my case has not been, I argued it, explained it, and I cited Everson estoppel, Magellan estoppel, Kasparov estoppel, extensively read it. And still the court, my lord, did not consider my contention. And I said, I am relying for convenience, I am relying only on Abdullah. And the judge says, the paragraph says, my friend read it. If there is a my friend reading it. Yes. If yes. Yeah. Yes. The General Secretary has said that paragraph yes. And then my friend reading from paragraph 10, right? Yes. My friend reading from paragraph yes. Last. Yes. Yeah. Here it is said. I heard my friend reading it, page 33. 33. Yes, 33. Let me read, my lord. At from page 32. Certainty of law, consistency of decision, and committee or court, all flowering from the same principle, converge to the conclusion that a decision once rendered must later be bind in like cases. This is the judge completely went wrong. That is about precedent. The rare decisions quoted non movere. If a court has found applies a principle, the concept of, for instance, the concept of removal of corporate bail. Removal of the corporate bail. That is the principle. That principle other future judges has to follow. So here what is reference is about certainty of the law, consistency of decisions, and committee of court, all flowering from the same principle, converge to the conclusion that a decision once rendered must later bind in like cases. That is precedent. I am not talking about precedent. I am a victim of judicata, something where there was no judicata, but the court found there is a judicata. Precedent and judicata are different. If a judge, the bench of 5 judges vote, 4 of the judges says 1 plus 1 is 0. I am bound by that is judicata. And the minority says 1 plus 1 is 2. That is precedent. In a subsequent case, the precedent, the decision that 1 plus 1 is 2, that is correct, that will be followed in precedent. So there is a difference between judicata and precedent. I was not talking about precedent at all. I am not concerned about anything other than the previous judgment, which is referred to as barring the present case. Then that is a prior decision rendered by a competent court on identical facts and law binding in subsequent proceedings on the same point, and such a decision must govern later cases unless shown to be per incuriam or rendered in manifest error. So the court completely lost sight of. I am asking what the relief is Abdullah sought. The court made a mistake. Acted contrary to law, correct it. I am not concerned about any precedent. I am not concerned about consistency. I am nothing about that. Is about public.
So, counsel, come to the conclusion.
Yes, and that is therefore, nothing was. My issue was not discussed. Then paragraph 10 in the instruction issue raised in the petition was directly a substantial issue. In early litigation referred above, when matters collaterally incidentally in issue may not ordinarily operate as a litigator, matters are directly a substantial issue considered in the prior decision consider litigator. That's a fact. There is no recidicator law. There is no recidicator. You have to rewrite jurisprudence. You have to write contrary to what Ulpian said. Recidicator pro veritate accipitur. It is on facts. A thing which is judicially decided as be treated as true. Not a law which is decided by the court as true. No. Recidicator pro veritate accipitur. A thing which has been judicially decided be treated as true. The court only. The court is bound by what the parliament has laid down. Court doesn't decide adjudicate law. Court interpret law. Court doesn't adjudicate law. This is completely wrong. Completely wrong. And then I take only one paragraph of Justice Nariman's judgment. Justice Nariman's judgment. And at paragraph 34(2). And Justice Nariman in his judgment start with that page 239. This book of this judgment, citation cannot be only one copy with me. That is 2018-16 SEC 228. Canada Bank, sorry, I didn't remember. Canada Bank. I seek a lordship's apology. The judgments of Nariman start Roma locuta est, casa vinita est. Yes. Rome has spoken. The case is ended. Rome spoke through his laws. One of the pillars of the Roman law is contained in the maxim, Judicata pro veritate accipitur. A thing adjudicated is receipt of truth. What is adjudicated is not law. What is adjudicated is fact. 1 plus 1 is 0. Black is white, white is black, straight is crook is straight. That is what a court decides. That is Judicata. The maximum of Roman law is based on two other fundamental maxims of law, namely interresto, republico, ut sit finit litium. There shall be an end to litigation. Interresto, republico, ut sit finit litium. It is in the interest of the republic that there shall be finality of litigation. Therefore, the court says right or wrong. 1 plus 1, a single judge, the court has decided 1 plus 1 was 0. That judgment has to be given effect to for one reason, that there should be an end to litigation, and the parties who agitated the same issue shall not be made to re-agitate. That is again, Justice Nariman has quoted it. Yes. Then this says, and there shall be an end to suit. And no more debate mistakes are the pro et non cosa, and no man shall be vexed twice on the same issue. Therefore, Judicata. No man shall be vexed on the same issue. If there are facts, 1 plus 1 is 0. Facts found.
So counsel, don't repeat the very same argument.
Yes. Therefore, nothing. My grievance is nothing has been decided. Only a mistake has been pointed out to the court, and the court is duty bound to correct it. And I quote Justice Vivian Ghosh in Surrender's case. Doctors pointing intention. Time for repentance. A court should, where it has made a mistake, it should correct itself. And this is Vivian Ghosh has pointing intention, repentance. The pointing intention, Latin means repentance. And the Pope did it. The Supreme Judicial Tribunal, or temporal and physical power. That is why Justice Nariman said, Roma locuta est. The Pope said, Roma locuta est, and claimed that he is infallible because he is prevented by the Holy Spirit from committing error. Now has accepted, yes, he made error. So therefore, my Lord, the error is on law, it has to be corrected. And the Judicata applies on adjudication on. But I just conclude, the doctor Judicata to apply. The notice decision can be given effect to, provided the parties are the same, the cause of action is the same, that the tribunal has jurisdiction, and there is a finality, adjudication of the list on its merits, either constructively or actually, and then a litigation, there should be an end to litigation, and that is on facts. And the other judgments has done great injustice to me, and is there to be corrected.
Yes.
State your plan. I'm not as familiar that both A.R. Anthony's case as well as Canada Bank have been treated to this court. Now I'm just reading two paragraphs of the judgment in the review petition. Paragraph 7.
Judgment?
In the review petitions. But this was specifically argued. Relying on the decisions of a constitutional bench at the fixed court in A.R. Anthony versus R.9, the learned counsel for the review petitioners would contend that in rectifying the error, no procedural inhibition should debar the court because it is well settled principle that no person should suffer by reason of a mistake of the court. If an order is irregular, it can be set aside by the court that made it on an application being made to that court either under rules of the court dealing with expressly with setting aside orders for the regularity of executive judicial duty if the circumstances warrant, namely where there was a breach of rules of natural justice. Relying on the decision of the fixed court in Canada Bank versus N.G. Subbaraya Shetty, the learned counsel for the review petitioner would contend that an issue of law which arises between the same party in the subsequent suit of proceedings is not res judicata if by an erroneous decision given on a statutory provision in a former suit of proceeding. The statutory provision is given effect. In such cases, the rights of the parties are not the only matter of consideration as a case of the erroneous interpretation of statute. Inter parties as a public policy contained in statutory provision cannot be set at all. So this and its matter was afterwards found against the appellants here. So even this court is now brought by this court's own judgment order and RP. It is not as if the first time these judgments are being cited and pleaded.
Yes.
That's all. I only reply one word from 34, para 34, 2 only, I believe my friend read from Canada Bank. But only read one sentence. Huh? Yes, Canada Bank, 34, 2, I don't have a copy, but I just read it from my paragraph 34, 2. An issue of law which arises between the same parties in a subsequent proceeding is now judicata if by an erroneous decision given on a statutory prohibition in the former suit or proceeding, the statutory prohibition is not given effect to. This is my case. I am repeating the sentence, paragraph 34. I provide the copy and I have given argument notes also. I am reading it again. An issue of law, this is by Justice Nariman.
Yes.
2018, 16 SEC 228, Canada Bank versus N.G. Subbaraya Shetty. An issue of law which arises between the same party in a subsequent suit or proceeding is not a judicata if by an erroneous decision given on a statutory prohibition in the former suit or proceeding, the statutory prohibition is not given effect to. In my case, by erroneous decision in an earlier proceeding, the statutory prohibition has not been given effect to. This squarely applies.
Separate order dealing
Maybe given a day's time to
Appeal 187 to 2022. Since it is reported that the land council so and so is having some doubts. Separate. Writ Appeal number 2629 of 2025. We heard arguments of the land council for the appellants and the land standing council for Dhanalakshmi Bank for respondents 2 to 4 reserved for judgment.
2 to 4. Argument on the
the learned counsel for the appellant would ascertain that the written argument notes shall be a brief argument notes shall be placed on record within 2 days.
Copy on us.
Within 2 days after serving copy to the other side for judgment on 17th at 4:30. 4:50. Yes, next case. The separate order. And the auto type.
Got it. I am from the review.
Yes. Who is the special handler?